Hi, I'm Kristy Burns, Head of Family Law at Owen Hodge Lawyers. Today we are joined by one of our very own, Ms. Pooja Kapur, Family Law Solicitor, to talk about how the state health measures impact family law orders. Pooja, how do the state health measures impact families, particularly where they have orders for the transition of children from one home to another?
Thanks, Kristy. Generally, parents should be aware that health orders are issued by the State Minister for Health. I would encourage parents to closely monitor the news to keep them up to date with what these might be. Parents who are subject to family law orders issued by either the Family Court of Australia or the Federal Circuit Court of Australia are still legally bound to comply with those orders. The state government has declared that it is a reasonable excuse for children to be transitioned between homes for the purposes of a changeover. I would encourage parents to carry a copy of their sealed orders with them whilst travelling.
Pooja, some parents may feel like they can't comply with their family court orders because their children are displaying flu-like symptoms. What should they do in this case?
Kristy, I would encourage parents to educate themselves with what the symptoms of the coronavirus might be. It's not necessary that if a child is coughing or sneezing that they do have the coronavirus. Parents should take their children to a GP if they are displaying these symptoms and get tested. If no test is required, then time in accordance with the orders should continue. If children are too unwell for changeover, I would encourage parents to keep an open line of communication, especially during these tough times, and convey their concerns to the other parent. Make-up time can always be arranged at a later date. The main thing that parents should be aware of is that there are legal consequences for not complying with orders. Coronavirus is not an excuse to not comply with the federal orders binding them. Contravention proceedings can be brought against a parent who have unreasonably withheld their child. These are complicated issues, but Kristy, I understand that you have some experience with interstate and international relocation matters of this sort.
Pooja, that's a very interesting question. Relocation matters are challenging and difficult at any given time. However, at the moment, interstate orders for the relocation of children do pose some challenges, but the state health measures are providing a reasonable exception to this. So you are best to take a copy of your orders when transitioning interstate. In relation to international relocation, this is a completely different set of circumstances where borders are closed in other countries and flights are limited. You should seek advice in relation to international relocations where you are seeking an application. You may wish to reconsider at the time in which you do so.
Thanks, Kristy. I hope you and your family can all stay safe during this time.
Thanks, Pooja. And on behalf of Owen Hodge Lawyers, we hope you stay safe and keep well. And remember, if you need any further advice, please feel free to contact us.